I guess as we're sort of used to in our space, the EU is again sort of flexing its muscles as a regulatory superpower, and is sort of ahead of the pack in terms of proposing, hard law around AI. And I guess there will be a lot of familiarity, I know, within the room in terms of the shape of the EU AI Act, but just so sort of everyone's on the same page. Whilst the model that Rebecca was describing for the UK is largely a decentralised model, what we have with the AI Act is much more of a centralised model, so a single horizontal law that cuts across sectors, across the economy, and regulates AI sort of wherever it arises within the economy, does it in a risk-based way. So that is an important part of the AI Act, and there are sort of 3 tiers of risk. Prohibited AI practices, things like your social scoring, behavioural manipulation, high-risk AI practices, which are the ones that will really interest businesses because those are the uses for AI that are permitted but are subject to strict regulation. So things like the use of AI for determining eligibility for health and life insurance. Maybe we had someone from Aviva on earlier. Credit scoring, all sorts of things that you'll be doing around employees and HR. So sort of various high-risk use cases that will be scrutinised very closely. And what is in and out of scope for high risk has been changing constantly as the AI Act draft evolves. And then sort of below that, everything else, which is sort of subject to sort of much softer regulation. We're sort of now at a crucial phase in the legislative process where we have sort of proposed final drafts from both the Council and the Parliament to sit alongside the Commission's original proposal. So we're now entering the famous trilogue negotiations and the sort of the back and forth and the horse trading that will be quite intensive over the next few months. And I know they're sort of looking to reach a final position this year, and then we'll enter a 2 to 3 year, depending on the final position, implementation period. So sort of where we were in 2016 for GDPR, where sort of businesses know this is the final text, this is what's happening. You've got 2 to 3 years to get your house in order before it goes into effect. And sort of what is the AI Act? I mean, the way I often describe it to people, it's a sort of curious, although in some ways sort of quite sensible, I think, hybrid between product safety law and sort of data protection law. So there's a whole sort of side to it that is about the technical conformity and sort of going through a conformity assessment process and sort of what, if you are the developer of an AI system, do you need to do to ensure the safety of an AI system before you put it on the market in the EU and you add a CE mark to your AI system. So that's the sort of product safety heritage. And there's a whole sort of interesting set of questions about how product safety around AI systems interacts with existing product safety regimes, whether it's for medical devices or for cars or for toys or whatever it might be. And then the other side of it, the data protection side, where it's sort of focused as well on, transparency and individual rights and fairness and these sort of core AI principles that, have been developed at the OECD level. And that's one of the things actually that sort of ties the EU approach together with the UK approach, and indeed with most approaches to AI regulation globally, that you have this sort of golden thread running through them of these core principles of what it sort of means to develop and use AI in a safe and responsible way. And it's things that will be quite familiar to us as data protection lawyers, because there's quite a lot of read across between those principles for safe AI and the sort of data protection principles in now Article 5 of the GDPR, so fairness, transparency, accountability, safety and security. So that's also a sort of core part of it. And I think, thematically, that's where everyone needs to get to in terms of AI regulation, is balancing the requirement for technical safety and sort of the stuff that is probably beyond most of us in this room, including myself, in terms of how we actually create the fundamental models, how we program the AI systems, ensuring that's done in a way that ensures the sort of the safety and fairness and security of the AI systems and models. And so getting that part right, and I think a big part of that we'll come back to international standards that I know, Rebecca, you're keen to talk about a bit more. And then the other side of it that is probably more sort of familiar and comfortable for most of the people in this room is the individual rights side of it. And so, the rights that individuals have, where those individuals are impacted by the use of an AI system, to understand that decisions are being made about them by an AI system, to understand at some level how that works, to have the ability to challenge that potentially, and even for certain, particularly high-risk use cases to perhaps be prohibited in some way. And then finally, obviously, the rights of redress, ultimately, if something goes wrong.